My name is Anne Peters. I'm a director at the Max Planck Institute for Comparative Public Law and Public International Law in Heidelberg, and a professor at the University of Heidelberg and others.
Thank you so much. In the statement on the Russian attack on Ukraine by the German Society of International Law, you've already answered the question of whether Russia is violating international law with this armed attack. Could you perhaps briefly summarize the statement again for those who are not yet familiar with it?
Yes, it's a pleasure for me to do so. The German Society of International Law did not itself issue the statement, but the board and council of the society stated on 24th February that Russia violated international law by breaching the fundamental principle that the use of military force against another state is prohibited. This is a fundamental breach of a basic principle of a peremptory norm of international law, so that all other states are obliged not to recognize the situation and are obligated to cooperate to terminate it by lawful means. President Putin pronounced various pseudo justifications which do not hold under international law and which therefore need to be denounced and condemned by international scholars, which everybody is also doing now, I think.
Thank you. We've all seen that President Vladimir Putin justified the Russian military operation in Ukraine in his televised address by saying that Russia had been asked for help by the Donetsk and Luhansk People's Republics. How would you assess this justification in legal terms?
Yeah, this justification does not hold because it is not permitted for an armed opposition to invite, in quotation marks, foreign military assistance. The International Court of Justice has stated this principle in its famous Nicaragua judgment of 1986, and this is, with all kinds of variations, still good law. And we see also how this leads to military escalation.
Thank you. And then what consequences does Russia face for this breach of law, like especially in terms of sanctions and judicial enforcement? How would you classify, for example, the complaint of Ukrainian President Zelensky at the International Criminal Court in this framework?
Okay, we have various courts which are already engaged. You have been referring to the statement of the chief prosecutor of the International Criminal Court, Mr. Khan, who said that the situation in Ukraine now warrants an investigation by the International Criminal Court. This is based on a previous submission of the state of Ukraine to the jurisdiction of the International Criminal Court. Ukraine issued such a statement in 2015 following the events in eastern Ukraine and the annexation of Crimea. And the jurisdiction of the International Criminal Court is open, one could say, for crimes such as war crimes and crimes against humanity and genocide, but not, and this is important, for the crime of aggression, which is the main issue here. But Russia is not a party to the International Criminal Court, and the unilateral subjection of Ukraine cannot draw Russia under the jurisdiction for the crime of aggression, because this is a special case which has been added to the statute only with the Kampala amendments in 2015, and there the options are very limited. We also have a new application before the International Court of Justice in The Hague. So not the criminal court, but the World Court. Ukraine has instituted a proceeding 2 days ago based on the Genocide Convention, which indeed gives the court jurisdiction also against Russia. The Ukrainian complaint is here that Russia is abusing the word genocide by alleging a genocide against Russians, which is aberrant. There is no evidence, there are no indications for such an allegation. And Ukraine now argues that this undermines the Genocide Convention and therefore infringes the convention and also infringes Ukrainian rights. I think that this is a problematic assertion. It's a very bold claim, but Ukraine did that because there are not many other bases of jurisdiction for the International Court of Justice.
All right, if we now switch from the International Criminal Court to the UN Security Council, we've all seen the resolution against Russia's invasion of the Ukraine has failed. How useful is this system then anyways? And doesn't it paralyze itself, or how could it be developed further?
The problematic legitimacy of the United Nations Security Council is a long-standing issue. And there have been reform debates since decades now. However, the reforms are not going forward for various reasons. As you know, the permanent 5 members of the Security Council have a veto power. And also in this situation, Russia already vetoed a resolution in which it was supposed to be condemned. The veto power is the product of the Second World War. Those powers who had won the war had, in designing the UN Charter, granted themselves this privilege, and that was at the time also accepted by all other states. Otherwise, the United Nations would not have come into being. But this position proves to be anachronistic because it now prevents all robust action against one of the P5 or against a state behind whom one P5 stands. For example, robust Security Council resolutions with regard to the Syrian war have been prevented by a veto of Russia, and condemnations of Israel are frequently prevented by a veto of the United States. Therefore, we have proposals to curtail the veto. There is notably an important initiative by France and Mexico, which asks for a self-commitment by P5 not to exercise the veto when genocide and crimes against humanity are at stake. But no other P5, not even the United Kingdom and the United States, follow this important initiative by France now. The other aspect, which is even more relevant here, is that, as I said, the veto will always prevent that one state, one of the P5, gets condemned by the Security Council. One could say that here, one state who is in reality a party or even a presumed perpetrator of crimes decides in its own cause. This would not be conceivable in any judicial setting. But of course, the Security Council is not a court, but a very politicized organ. And that's why we have this mechanism, which could be completely undone only by a formal revision of the charter. However, for such a charter revision, the P5 also have to agree. And they will never agree, at least some of them will never agree for the time being, to such an amendment.
Thank you. So let's come back to the European Union. Yesterday came the news that the Ukraine has applied for membership in the European Union. And what does this mean in concrete terms, for example, in relation to Article 42 TEU?
Well, becoming a member of the European Union requires, of course, complicated procedures. So the simple request for membership is only a first step of a long journey. And you remember that the plan to conclude an association agreement with the European Union was the trigger for the Maidan protests in 2014, which then led to the annexation of Crimea and the destabilization in eastern Ukraine and so on. So the relationship to the EU is a very important issue. Now, as you mentioned, the Treaty on the European Union has one clause, Article 42, Section 7, which says that if one member of the European Union is attacked by military means, then this will trigger the right to self-defense also of the other European Union members. And the TEU treaty here refers to the Charter of the United Nations and to its Article 51. So this would mean, one could say, this is a strong position for European Union member states. And maybe you remember that in 2015, when there were the terrorist attacks in Paris on the discotheque and so on, that then Germany also mentioned exactly this clause and said Germany has to send military support to Iraq to combat the Islamic State because of the obligation to help France. So this was one example when this clause already played a role. But even without being a member of the EU, collective self-defense is always an option. Ukraine can ask and asked for help, just as the Iraq in 2014 asked for help against the Islamic State attacks. And the other states can, without being bound together by membership in one organization, furnish military support under the heading of collective self-defense.
Thank you.
As well as the news of Ukraine applying for the membership in the EU, we have heard about President Putin putting deterrence forces on alert. This includes nuclear forces. What do you think, what would the use of nuclear weapons mean internationally, and how could or would one react legally in such a situation?
Well, the nuclear weapons is, of course, a highly troubling topic, not only in legal terms. The situation is currently that there is one treaty, the Non-Proliferation Treaty, which dates from 1968, which allows certain states to possess nuclear weapons. And Russia is one of these states, which lawfully under that treaty has weapons. In 2017, another treaty was concluded, and it also entered into force last year, which goes much further. This is called the Nuclear Ban Treaty. And this treaty, which was drawn up on the initiative of smaller states, but also, for example, Austria sponsored this treaty, attempts to ban completely nuclear weapons. So it's a totally different take from the Non-Proliferation Treaty. But this ban treaty has not been ratified by not by Germany, for example, not by Switzerland, and not by any state which possesses admittedly or secretly nuclear power. So here we have I think there is a stagnation, and there is also one important advisory opinion by the International Court of Justice from 1996, where the General Assembly asked the question whether the use of nuclear weapons would be per se illegal. And here the court couldn't reach a definite conclusion. The court, in that advisory opinion of 1996, said in the end that in the exceptional and extreme situation that the existence of a state is at stake, it could be lawful that the state uses nuclear weapons to defend itself. So the courts shied away from denouncing nuclear weapons completely, although I think that a nuclear weapon by itself is incapable, for example, of distinguishing between military and non-military objectives. And therefore, I think that the use of a nuclear weapon is per se a violation of a basic principle of the rules of humanitarian law. And in any case, the use of a nuclear weapon for an aggression to attack another state is definitely, it's of course, completely unlawful. But to further work in the direction of banning the possession of nuclear weapons, that is, as I mentioned with the example of the Nuclear Ban Treaty, a very, very difficult path. And in the recent decades, the disarmament activities have rather slowed down or been reversed. So we are in a very difficult situation.
Okay, thank you.
So after everything we already talked about, the question is, of course, has the international law lost its force when it's broken in this way by Russia? What would you say to that?
At first sight, it's of course very, very critical that a fundamental principle of international law has been violated. On the other hand, I find that the reactions of the international community, of all other states, non-state actors, is so uniform that one could say that this rule is currently being actually confirmed. Of course, if the law is breached many times on a large scale, the rules are undermined. And because in international law, we have a fairly small number of actors, let's say 193 states and international organizations and so on, but in comparison to, let's say, 80 million inhabitants of Germany, this is a very small number. And so that means that if one state breaches the law in such a crime, this weighs more heavily than one attack. For example, the attacks in Heidelberg a month ago. This was a mass murder, but in comparison to 80 million inhabitants, it still does not affect the basic rule that murder is prohibited. No one thinks that this rule has been weakened by this one crime. The crime by Russia now has a bigger proportion, statistically speaking. However, we must not forget that in all other international relations, and in most other international relations, 193 states with thousands of millions of kilometers of borders respect the rule, respect territorial integrity, respect the prohibition on military force. So I have the feeling also with regard now to the strong economic sanctions which are taken, that this might even result in a confirmation of international law.
All right, if we now think about the future of the international law, if it might, might be possible to develop the international law to prevent such disasters in the future, so we can basically act proactively with the international law in such cases, or is it not necessary?
It would surely be better, for example, to get around the problem that we have no international jurisdiction against the aggressor, against President Putin. It would be possible, as it was done after the Second World War and at other instances, to create an ad hoc tribunal. However, this cannot be done by the Security Council as it was done after the Yugoslavia wars, because Russia will be against it. The General Assembly of the United Nations does not, I would say, have the competence to set up such a tribunal, because its powers are mostly recommendatory. So, yeah. The other issue, namely the reform of the Security Council so as to exclude illegitimate veto of a state which is embroiled in its own conflict and which is the cause of the problem, is also one way which we discussed just in your previous questions. Then there is, of course, also the theoretical option to create a new international organization besides the United Nations. I don't think that this would be a good idea, but we have seen such things. For example, China was dissatisfied with the World Bank and the International Monetary Fund and created its own Asian bank. So these things have already been done. I cannot predict now how the story will go on, and this will depend, of course, also, unfortunately, on how this horrible war will go on and hopefully end.
Hopefully, yes. Thank you so much for answering all of our questions. This was very helpful.
Yeah, of course.